And this is chapters, it talks about the nature of corporations. And one of the things is that we know that the people on this call tonight are all students of business. They have an interest in this area. Many of you are presently working in businesses, even though you're pursuing a degree at the same time. And of course, if the business is of any size at all, it is probably a corporation. Might be an LLC, but it's probably a corporation. And so we're going to talk about the real getting started, some real nuts and bolts aspects of the corporation. Now, of course, we start with a picture here of a gorgeous conference room. I have a very nice conference room here at my Heights office, but it is nothing compared to this gorgeous room. And of course, this would be one of a very successful corporation with one of those fancy offices in a high-rise building, generally speaking. So we're going to define incorporation. We're going to talk about incorporation. One of the very important legal topics is piercing the corporate veil, and a parallel concept, the alter ego theory. Talking about promotion of justice, talking about involuntary dissolutions. And toward the end of the chapter, we'll talk about consolidations, mergers, and acquisitions. I want to talk for a minute about the Amazon Whole Foods deal. And if any of you on the call tonight have some inside information on that, I'd be glad to have you share it with the class. This happened, I think, about 2-something years ago. Whole Foods, which is based out of Austin, decided to put itself up for sale. Frankly, my observation on Whole Foods putting itself up for sale is that they knew that the end was near. And the reason I say that is because Whole Foods' big hook was the interest in the upper income group of Americans in buying organic products and organic other things like vitamins and baby food or whatever. And so it expanded and traded on this interest in organic foods. The problem with this is that when they went up for sale, Kroger, Randall's, which is owned by Safeway, and H-E-B, and everybody else under the sun now sells organic everything. You go in the produce, there's a section on organic, there's a section of regular produce. Go in the grocery aisle, there's separate aisles. My local Kroger's here in the inside the Loop area have a couple full aisles just dedicated to organic and so-called healthy foods. So the hook that Whole Foods had of saying, well, we've got the market on organic foods, and this no longer unique. They no longer have a hook. So I think the founder of Whole Foods, again, they were based out of Austin, Texas, as many of you know, decided to dump the operation rather than to continue to run the risk that they were going to really get sliced up in the marketplace. So I think this is a pretty interesting situation. I've actually been to one of the newer Whole Foods operations on the North Loop here near Yale in the North Loop. And I can tell you that I've been unimpressed with it. You can use your Prime card if you're a member of Amazon Prime to get a discount there, but it's still a pretty expensive experience unless you're buying something that's particularly on sale. But it's really interesting. Now, they're talking about merger here. This is really an acquisition. Amazon did not have a grocery operation, anything like a grocery store, until they acquired Whole Foods. In fact, that's one of the reasons why the Department of Justice probably did not interfere in the acquisition. And frankly, it was probably also a little bit of a bailout, although I don't know that anybody will admit to the fact that it was being done as a bailout. So what's a corporation? Artificial, intangible person created through a process provided by state law. Now, especially pay attention to that last statement. Each state sets up corporations. Now, there's a couple states that stand out. Texas does not. The best known state for major corporations to be incorporated is Delaware. Now, Delaware has faded in recent years as the preferred corporate base, but it is still a very popular place. About 70% of publicly traded corporations are still incorporated through Delaware. Now, another state on the back end of this thing is Nevada. Nevada is known as a sloppy state for establishing public corporations. So a lot of questionable business ventures set themselves up in Nevada. And so it's almost become a black mark that if you see a business that's being promoted through a promoter, we'll talk about that in a couple slides, that if you see they're incorporated in Nevada, it might be a good idea to take a pass. And in fact, some Nevada corporations then go and reincorporate in Delaware because of the negative connotation of being incorporated in Nevada, particularly with different lead investors. So a couple considerations. A legal entity is separate and apart from the persons or entities that it created. Rights and duties are separate and apart from its shareholders. Corporation is subject to the doctrine of respondeat superior. The corporation is subject to the responsibility for its employees. Now, we look at corporations as public and private. There are a great deal more private corporations than public corporations. Public corporations generally means that the stock is available for sale to the public, usually listed either on the pink sheets or on over the counter or on one of the major stock exchanges of various size. And but there's a lot more of them that are not traded on the exchanges or made available. The corporations may be profitable, for profit, or not for profit. Now, I'm going to just speak about how it's done here in Texas. In Texas, for a for-profit corporation only needs one incorporator. A not-for-profit corporation in Texas needs 3 incorporators. Now, the second part is that a not-for-profit corporation only pays a tiny registration fee in relationship to a for-profit, significantly more. So the state wants to know if you're setting up for-profit or not-for-profit. Now, what I want to focus on here is there's, I think, a little misunderstanding about a not-for-profit. I think some people think they just go to Secretary of State, say, here's my few bucks. My friends and I want to do this nonprofit. Well, that's fine. You've set up a nonprofit corporation in the state of Texas. Well, here's the problem. That's not recognized by the Internal Revenue Service. So your next challenge is you need to register that not-for-profit with the IRS in order to be recognized formally as a not-for-profit. Now, many students come to me over the years and talk about setting up a not-for-profit, some type of family charity. Sounds pretty straightforward. It's pretty simple. The problem is that the Internal Revenue Service is a fairly jaded operation, and they want to know if it's a charity, meaning that money given to that nonprofit is for public purposes. They want to make sure it's really for public purposes. And I'll tell you one of the things I ran into. At my previous university, I set up something very simple, a scholarship fund for the business school of the university where I worked. It took over a year to get the IRS to give us a blessing as a charitable nonprofit organization so that the money given to the scholarship foundation would be deductible for charitable purposes. So the key point I'm making here is a not-for-profit may not be viewed as a charity. And if it's not viewed as a charitable operation or a religious operation, money given to it will not be deductible for tax purposes. A good example of this, I'm a recent member of the board of directors of the Heights Chamber of Commerce. That is a not-for-profit organization. However, payments made to the Heights Chamber of Commerce must be classified as a business expense. They're not deductible just because you're giving money to a nonprofit chamber of commerce. So it's important to keep in mind how this is structured. On the for-profit side, we're going to talk a little bit more about the structure of that. Okay, I hear some background noise there, but everybody make sure they've got their mics muted. Now, this is a great example of how individual shareholders may get exposed to liability. So when can individual shareholder be liable for the acts of the corporation? Well, that's our ultra vires. If something is being done that's illegal, their shareholders are going to be responsible for that type of fraudulent or other illegal conduct. And so it depends on their individual conduct, not necessarily their position within the corporation. So the corporation is not a be-all and end-all protection from liability, depending on the individual actions of specific shareholders. This is a pretty good outline here. This is chapter S7. Slide S7 from chapter 37. And the articles of incorporation. And this is, again, pretty standard across multiple states. You have to have the names and addresses of the incorporators, name of the proposed corporation. Now, just a quick note here. One of the most difficult things today, especially in a large state like Texas, is to find a unique name for a corporation. You cannot select a name that is already in use, that is already protected in the state of Texas. So one of the things that a lot of people do is they pick the name before they submit their incorporation paperwork so that they can get that done as soon as possible. And so some of the things I recommend is to use Greek words from mythology and to come up with fanciful words. Google is probably a very good example. Yahoo are very good examples of fanciful words. But in any event, it is not a picnic to get a name approved through the state of Texas Secretary of State. Now, it mentions the object for which it is to be formed. Most of us, when we set up corporations, say for any and all lawful purposes. So very broad charter. And in fact, many companies change the direction that they're going in as their corporation moves forward. Proposed duration, one of the great advantages of corporations is they can have perpetual duration. Most of the corporations I've been involved in setting up are perpetual. Now, you need to have a registered office in the state of incorporation and a registered agent at that registered office. Now, for large corporations, the way that they handle registration is through a hired hand. And the best known of those is CT, 2 letters, CT Corporation. And for instance, we recently served a CT Corporation in its Dallas office for a corporation that did business here in Texas. And of course, details of the stock. Now, small businesses setting up a corporation, it was very common to set up 1,000 shares of stock at $1 par if you do have par stock. And now you say, well, gee, that's not very many shares to sell. Well, here's the point. You could be in some states like Virginia, where I also practice, they charge you an annual franchise fee based on the number of authorized shares of stock. So when you're little, you don't want to have a whole bunch of shares because you're going to have to pay for them. I think in Virginia, they'll let you have the first 25,000 shares for free. But if you're going to list your stock on the stock exchange, then you need hundreds of thousands of shares. And then, of course, you're going to owe this franchise tax to the state of Virginia. So watch for that regarding the stock of the corporation. What's normal, each incorporator signs the charter and the application sent to the Secretary of State. Secretary of State endorses it, signs it in, issues it a unique number, returns it to the incorporators. And then it says incorporators file it in the proper recording office. This is if there is local recording required. Texas is pretty flexible on this, but some states require registration at the local level after the state level is done. Once this has happened, then there is an election by the incorporators of a board of directors, and the board of directors then approve the bylaws and also appoint the officers. And it says the corporation only has the powers conferred on it by the state that creates it. Well, again, the powers are pretty broad for most corporations because it's any and all lawful purpose. But if a corporation is set up with a narrower objective, then that is a limited objective. Now, one of the problems that we have in corporations is called ultra vires. The acts of corporation that are beyond the authority express or implied. And when I was still litigating cases, which is a while back, I actually litigated a case of this nature. And these cases are called piercing the corporate veil. How do you get to the people behind the corporation, hiding behind the corporate veil? And so in this particular case, 4 retirees loaned money to a corporation. The corporation was operated by a wealthy individual. And with first, you say the first name of that individual was, say, Jeff. So what happened is that the retired individuals loaned money to the corporation because they were like, hey, Jeff's really a rich guy. He's not going to stick us. He's going to make sure we're taken care of. Unfortunately, less than a year after these 4 loaned in the money, the corporation went broke and shut down. And so the 4 investors went to Jeff and said, hey, we expect you to make us whole. We invested the money in the corporation, loaned the money to the corporation because we thought you were behind it. And Jeff said, foolishly, I'm not responsible. You guys didn't get any personal guarantees. That's your sad luck, tough luck. Now, the problem is because of several different issues. One of them is the president of the said corporation represented to these 4 investors that Jeff indeed would act as a company or corporate guarantor. And number 2, this was a but-for situation. None of them would have loaned money had they known it was a strictly thin situation like the Jeff tried to present it. So in any event, I agreed to litigate the case for the 4 investors as a group. And what we discovered is that the corporation had engaged in a number of acts outside of its responsibility. For instance, both the Jeff, basically the owner of the corporation, and the hired president of the corporation had paid their children's college tuition and their children's college automobiles out of the company's regular checking account. This is a clear-cut violation of the separation between a corporation and its members or shareholders or employees. And because of that, they could very well have set up a situation where the judge authorized piercing the corporate veil. Now, just quickly, what happened in that case was that the case did settle. Jeff and his colleagues became convinced that I was going to prevail in the case, though I was not nearly as certain because it is so difficult to pierce the corporate veil here in Texas that they did agree to 50 cents on the dollar plus some legal fees. And we were able to get the case settled for that. But it's still a pretty tough road. So again, a little bit of the thinking here is if you are a participant in a corporation, it's important to keep the books for the corporation separate from your personal books and don't meddle between personal interests and company interests. Now, something I think I mentioned very explicitly on Tuesday night is that a corporation is only domestic if it's set up in the state where you are. Any corporation that comes into your state to do business is a foreign corporation, and they need to qualify to do business by, and it's a little more complicated than filing a copy of their articles of incorporation, Secretary of State. They need to actually file to be authorized to do business in the state. And if something is a business that is simply visible in a state is probably not going to be required to register to do business in that state. You're going to need a little bit more activity, like a field office or something like that. I want to talk for a moment about promoters. Promoters, generally speaking, have a fairly poor reputation. They're usually considered a pretty negative aspect of the federal securities laws. Some of you may have seen a somewhat recent movie called Boiler Room, which is our people pumping different stocks without any ethical basis on how they're pumping those particular stocks. But a promoter can be helpful in helping startup businesses, sometimes consolidating them and going out and presenting a package of startup small business stocks to investors. Now, I want to introduce you to an important term right here, blue sky laws. Anybody want to take a guess at what blue sky laws cover? How about where the term comes from? How about the first state that had blue sky laws? All righty, I hope all of you are paying attention. But blue sky laws are state securities laws. So you have the federal securities, the SEC, Securities Exchange Commission. And at the state level, you have blue sky laws. The concept of blue sky is that virtually everything is a security that is covered by the state law. It's under the blue sky of the respective states. And a bit of trivia is the first state securities laws have been out for a little over 100 years, and that state was Kansas of all states. I would never, unless you know that, it's not one that you're likely to guess. Now, when a promoter puts something together and says, hey, I'm putting a package together, I'd like you to participate, the promoter is presenting themselves and basically backing the particular security that's being put out, the reputation of the promoter. So this can be a very risky situation. Now, I have only rarely been approached by promoters, and generally speaking, it's not been a great impression on my part. Usually it's a situation where you say, gee, you guys, pretty amazing. One of the more interesting times I was approached is I had bought a penny stock, and the penny stock had gone through some very hard times, and my investment in the penny stock was really compromised, was really beat up. And then a promoter out of the clear blue calls me up and says, hey, would you like to buy some warrants? And you can get some stock now and get some stock in the future at the same price. And the problem is that I had lost so much money up to that point on that particular situation that I wasn't under any obligation to continue to participate in it, and certainly had no a particular interest in buying more stock in a company that had damaged me so badly with my initial investment in that company. And subsequent to being approached, which was over 2 years ago, that corporation has continued to be a very poor performer in the stock market. And it is possible to protect promoters depending on how they promote stock of startup corporations. So what are some of the theories of corporate liability that could make it liable for the promoters? Offer and acceptance theory, consideration theory, and quasi-contract theory. And these are explained in the book. Basically, it's not that large a deal. Again, I think stock promotion was a bigger deal in the 1920s to the 1950s, and does not seem to be as much of an issue today, although, of course, we have different GoFundMe situations and things like that. But generally speaking, the law does tend to protect the promoter as long as the promoter identifies the stock that it's selling and disclaims liability. Now, the PIML case is an excellent example of holding promoters responsible. But notice, for the yet-to-be-formed corporation, they signed documents on behalf of the entity, and they discussed business strategies with the plaintiff. So the court found that these individuals were liable promoters. Now, as I mentioned a few minutes ago, I gave you an example of piercing the corporate veil, the case I actually personally litigated, where the wealthy individual eventually rolled over and paid 50% on the dollar. But what was interesting about the case is the individuals who had loaned in this money, these 4 individuals had loaned in some of their retirement funds, could have been very easily protected if they had just required Jeff, the wealthy individual, to sign a guarantee on their loan documents. Now, I don't know if he would have done it, but if he wouldn't do it, it would have at least told the 4 persons that they shouldn't loan the money to the corporation because it wasn't as solid an investment as they thought. And so sometimes we'll promote justice because it's important to hold individuals liable, but again, particularly in cases of fraud or criminal acts. Now, parallel to our recent discussion of the dissolution of partnerships, corporations do have to follow some of the same procedures. The written consent of all the shareholders, or if it's instituted by the board of directors and approved by 2/3 of the shareholders. And so you need to provide notice to your creditors. You better not hand out any of the money until everybody who is owed money gets their share. Now, if the state proceeds to shut the corporation down, that can be a quo warranto situation. And keep in mind, the most common way that corporations are unincorporated, if you'll pardon that concept, is when they do not provide the franchise taxes and keep their fees paid to the state in which they're incorporated or other states where they're authorized to do business. And so if there are requirements, and most corporations are required to do annual filings, both and often paying some fees, and many times corporations are not successful. So what happens is that the people that set up the corporation stop paying the annual, filing the annual forms, and stop paying the annual franchise taxes, and the charter of the corporation is forfeited. And that's where you're going to see that, or quo warranto, where the corporation may be viewed as being set up to accomplish fraudulent or illegal ends. Now, why would the shareholders institute a dissolution? In the case where there's a deadlock regarding how to proceed, illegal, fraudulent, or abusive conduct by the members of the board of directors or officers of the corporation, or for the protection of minority shareholders. Now, you can also have, and remember, we talked about this already in the bankruptcy chapter, you can also have a bankruptcy initiated by the creditors. Remember, we talked about having an organized process of resolving things for the creditors. This is a key slide: consolidations, mergers, and acquisitions. A good example of a recent big consolidation is BB&T Bank, branch banking and trust out of North Carolina, and SunTrust Bank, also operating in the Southeast and some parts of the Southwest. So the two corporation banks have combined, but the new corporation is called Truist, Truist. I'm not fond of the business impact of that, and I haven't really, thought about more about it, other than the fact that you have a brand new name, this Truist name, instead of BB&T or SunTrust. In a merger, one corporation absorbs the other and continues to exist, but the target corporation is dissolved. This looks like what is happening with the T-Mobile Sprint merger. I thought it was going to be a consolidation. However, it's being presented to the public as an acquisition of Sprint by T-Mobile. So you might note that in the way advertising and things are structured. And then sometimes you have an acquisition where one corporation goes out and just buys another corporation, sucks it in, and just dissolves it into the existing corporation. So what are the procedures? Generally speaking, the board of directors has to put a resolution together saying, we want this to happen. And then it's permitted to the shareholders for approval. The shareholders generally must approve the plan by 2/3 vote of all shares. Articles of consolidation or merger will be prepared and filed with the state. Says certificate of consolidation or a certificate of merger will be issued. Now, one of the areas we get into, and this is usually dealing with public corporations or corporations where there's been some distribution of the stock and there are stockholders who disagree with what the majority situation of the corporation is doing, the majority shareholders. And each state or most states have a specific rule protecting the minority shareholder, usually to make sure that there's an opportunity for them to be bought out if they don't agree with a business move by the corporation. Now, they're entitled to be paid the fair value of their stock on the day preceding the vote. So there's several different accounting methods for calculating the buyout in those situations. Now, you might anticipate that when minority shareholders are bought out, they often gripe about what they get. And so the question is whether the court had sufficient evidence to make a good decision regarding value. So what are the liability of successors? Well, one of the unique features of corporations is they have indefinite duration, which means if you acquire the corporation, lock, stock, and barrel, meaning the stock, then you have all of the liability that was in that corporation. That is a surviving corporation. Now, if it is an asset acquisition, it's messier because you have to list each asset and each liability that the direction will go under. But it's a little bit of a different circumstance there. Because they do not get the liability unless it's specifically itemized. Now, this can either be every desk, every car, every employee liability. And so it can be rather messy acquiring assets versus a fairly clean transaction where a stock certificate is surrendered for the number of shares, outstanding shares of the stock. This is another key slide for Chapter 37. Horizontal merger, two businesses in the same industry. You might say the Sprint T-Mobile merger, a good example of that. Vertical merger, this is where some of the big oil companies have bought some of the big oil service companies. And then a conglomerate merger, merging of companies that are unrelated. And I just, for the record, work for one of the largest corporations, conglomerates in the world during the 1980s, and it was a very interesting experience. Unfortunately, due to incompetent management, the corporation, despite its massive size, failed very miserably.
Isn't there a difference between nonprofit versus not-for-profit? I think I heard you saying those words like interchangeably, but I guess.
Well, when you incorporate them at the state level, basically the state sees it as they're not for profit, but and nonprofit. I've always used them interchangeably. I don't know that the state cares if you use one term or the other. However, you're asking an important question, because when you get with the IRS cares a lot because they want to know if you're seeking to have payments made to the corporation to be tax deductible. And so I usually focus on that. So I usually focus on whether it's a charity or a religious organization, educational organizations, which are recognized as not taxable or taxable deductions versus, like I said, a chamber of commerce or a political party, things like that, that are not for profit, but the payments to them are not tax deductible, unless there's a business purpose. So did that answer your question?
A little bit, because I guess I know credit unions are nonprofit. They usually don't use the term not-for-profit. I think just because of how when they make money, it goes back into the credit union, but I guess in different areas, maybe. I don't know.
Right. But again, a credit union is a great example of a not-for-profit business, but the payments to the credit union are not tax deductible. But if you have a business account there and they charge you business fees, then the fees that you pay them are deductible. The interest you pay on the loans are deductible. And they are under certain restrictions regarding surplus. So a credit union is, and I'm getting outside my area of expertise because I'm not an accountant, is that the credit union has to maintain legally required balances so that it is secure in its lending practices. But beyond that, then it needs to adjust its business practices, or it can be assessed cost on its surplus. But again, you're kind of getting in the weeds there on that. But yes, the credit unions are owned by their members, and they're viewed as not-for-profit corporations.